We are so excited to be bringing you Danny Sheehan tonight. And it means so much to us that we gather as community, that we're connected, and that we acknowledge this beautiful time when we can go deep and do a reset for who we are and why we are here on this planet right now.
We welcome you all tonight to Tatanka's Living Room with Danny Sheehan. We honor and give thanks to the Ohlone people, the Castanoa, all the indigenous tribes whose land that we're on in our home in Santa Cruz, and wherever you're living. What Romero is doing is so unique and so important for us to ensure life on this planet that we're asking you to, as Danny speaks, go to your heart and figure out what you want to do to support Romero. They're particularly asking for sustainable donations. What Romero is offering as a thank you for those of you who do give over the next 3 or 4 days is a special meeting next Saturday at 5 o'clock, a Zoom meeting with Danny Sheehan and Chase Iron Eyes. So this is an enticer for those of you that can help out either with a sustainable or a one-time donation. You will be included on that call. Okay, Danny is going to be talking on COVID and the Constitution and whatever else he has put together. Thank you, Danny. Welcome.
Far out, everybody. Hi. Happy May Day, actually. This is May Day. A lot of extremely important things have happened since we were all together last. You have Governor Newsom here in California asserting publicly that he is going to conduct himself here in California as though we were a nation state. And he has the right to, in defiance of the restrictions that are being demanded by Trump, that Governor Newsom has the authority to enter into interstate agreements and compacts with the state of Oregon, with Governor Kate Brown of Oregon, and with Governor Jay Inslee of Washington State to coordinate their activities with regard to the protocols that they're going to be following with regard to the opening of their states economically. But you've got this peculiar assertion on the part of Donald Trump, not only that he says that he has absolute authority in this situation, but that he can do absolutely anything he wants to do under his authority. And he's citing certain secret powers that he says that he has that he can't tell us about, but there's some sort of authority that he has to do whatever it is he wants to do. And this has sent chills up the spine of constitutional scholars around the country. But there are other developments that have been going on. Very importantly, the chief judge of the United States District Court in Montana has on Tuesday issued an order striking down the authority of the Trump administration to grant general permits to the Keystone XL tar sands pipeline to cross some 1,000 separate bodies of water between Alberta, Canada, and Nebraska, where they're trying to build the other extension of the Keystone XL pipeline. The Trump administration in 2017 organized and issued this nationwide permit that allows an expedited process by means of which all these oil corporations and natural gas corporations can traverse various bodies of water without having to comply with the requirements, not only of the National Environmental Protection Act, but also the Endangered Species Act and others. And so that the judge on Tuesday struck that down, said that that was illegal under the Environmental Protection Act and under the Endangered Species Act. And the Trump administration, the William Barr Justice Department, filed an emergency motion asking him to stay his order, and he refused. So that this is a temporary victory that's been won. There are still challenges, but the major challenge that's been raised to his order is that it goes beyond the Keystone XL pipeline to cover the entire country. With regard to the Dakota Access Pipeline, Judge Boasberg from Washington, D.C., in the Federal District Court in Washington has now finally acknowledged that the permit that was granted by the U.S. Army Corps of Engineers pursuant to the order of Donald Trump in his second day in office was illegal, that it violated the Environmental Protection Act, and that it never should have been granted. And he's now taking briefs on the question of whether or not he's required by law to shut off the flow of oil from the pipeline. In fact, to determine whether he's legally required to order them to take the pipeline completely out of the ground from Dakota Territory. So this briefing schedule is going now. Just 2 days ago, the Attorney General for the state of North Dakota filed an amicus brief stating that the closing off of the oil flowing through the state of North Dakota was going to be a major tragedy to the state of North Dakota. And so that they've pleaded with Judge Boasberg not to shut off the oil, even though not a single drop of the oil is going to North Dakota. The oil is coming from the state of North Dakota. What I want to do is I want to direct my attention to a number of the constitutional issues that have been raised by this present coronavirus pandemic that we're all going through right now. Now, there are two different ways that we can approach this. One is to take the issues in the order in which they've been attracting media attention, or they've been attracting lots of protests or complaints on the part of the population, different portions of the population, in order. Or we could take them in order of what I think, based upon my understanding of the Constitution and the events that are going on, what the most important, in order of importance, are of these issues. I've chosen to do the latter because I think it's important to take them in sort of sequential order, because you can see that if the most important of them can be addressed, it may move the rest of them. But let's get started on this. As I pointed out in our conversation 2 weeks ago, it's in these times of extraordinary stress, with people being ordered to stay in their homes except for a necessary transportation to the drugstores for pharmaceutical drugs and prescriptions, and to the places that are necessary, such as getting food supplies. And the governors having major confrontations with the president over who has authority to do what. Now, orders being entered by a number primarily of Republican governors to start opening their state, to demand that businesses be allowed to open and that the commercial community start to be able to generate funds for themselves again. There's a number of issues that are flying around right now. But when you see armed citizens with full body armor wearing M16 automatic rifles around their neck and marching into the legislative halls of Michigan and other states, demanding that the legislature overrule the rulings of their governor, extending the stay-at-home orders into this month. The people may view all of these things as very important public policy problems, but the fact of the matter is they raise fundamental constitutional questions that we need to deal with. And as I pointed out in our last meeting, it's extraordinarily important in times of stress like this that we look back at the actual provisions of our Constitution, because it's in moments like this that the entire fabric of our government is under stress, and that we want to look back and understand what the fundamental agreements are pursuant to which our government functions. That certain authorities reside with the President of the United States, certain authorities reside with the Congress of the United States, certain authorities reside with the governors of the several states and with the legislatures. And of course, various types of authority reside in the various court systems, the federal court systems and the state court systems to address these. This entire structure has been set up over many years to try to be prepared for situations like this, so that there are rules in place and there are juridical institutions in place that can address these problems in a compassionate, yet calm and centered and deliberative manner. And so that I'm advocating here that we, those of us, the 100 or so different stations that are all tuned in here to talk with us, with multiple people at some of the points, participate in this discussion and reach out to a number of our friends and family members to try to share some of this basic information about our Constitution, so that we can all come to some kind of an agreement as to what the protocols are pursuant to which some of these disputes need to get resolved. The first of these, and one that I think is probably the most important constitutionally, is this claim on the part of Donald Trump that he, as the President of the United States, has these unilateral powers that are secret from all the people, secret from the Congress of the United States, a secret from everybody except him and a few others, as to what authority he thinks he has to, quote, do anything I want, he said, in these kind of situations. We've undertaken some investigation of that here at the Romero Institute, and we discovered that what he's really referring to are a set of executive orders that were issued by W. Bush in the aftermath of 9/11, under the whip hand of his vice president, Dick Cheney, whose attorney was David Addington, who was the author of many of these torture memos, authorizing torture at Abu Ghraib, and promulgating the history of the unilateral executive, that somehow the President of the United States is a standalone authority, taking his precedent from the royal kings and rulers of Europe, and that unless and until he's been explicitly prohibited by the Constitution of the United States from doing whatever he wants to do, that he has the right to do that. And that somehow the Constitution of the United States doesn't constrain him from doing these things. Now, it's important to remember that the source of authority that he is clearly referencing here was a unilateral executive order issued by the president himself, George W. Bush. So what he's basically saying is that this was an effort on the part of Vice President Dick Cheney and his lawyer, David Addington, to basically get on the record, even though it was secret, what their position was as to what the kind of extensive authority is that the president has. And what they wanted to do is take advantage of the emotions of the immediate period following the 9/11 events to codify this type of power, so that they can have a record established that this is the position that the executive branch takes. And the danger of that, of course, is now being realized because Donald Trump now knows about those executive orders, and he is leaning into those and starting to rely upon those for his power. This issue has been addressed a number of times in our constitutional history. One of the very first times was when Abraham Lincoln, during the American Civil War, unilaterally suspended the right of habeas corpus, the right of an American citizen, if they're taken into custody against their will by government authorities, has a constitutional right to be brought before an independent magistrate and have the magistrate determine whether or not there's any probable cause to believe that this person has committed any particular crime. And if there is not such an offering, that convinces that magistrate that it's more likely than not that that citizen has committed a crime which would justify him or her being taken into involuntary custody by agents of the state, that person has to be released by the order of the court. This is a profoundly fundamental right that exists at common law and exists in our United States Constitution. Yet Abraham Lincoln unilaterally rescinded that during the Civil War. And it was one of the things that was cited by those in the Confederacy as justifying their characterization of him as a tyrant. And as you remember, John Wilkes Booth, when he shot and killed Abraham Lincoln and jumped to the stage of the Ford Theater in Washington, D.C., shouted out, "Death to tyrants," basically garnering unto himself the authority to do this because of the violation of the Constitution on the part of Abraham Lincoln through this unilateral order. We also have another example of this having taken place with Franklin Roosevelt. And I'm citing presidents that we hold in some esteem to show that it's not just some crazies, the presidents that do these things. Franklin Roosevelt, after the December 7th, 1941 attack on Pearl Harbor in January, issued I think it was actually December 28th, I believe it was, issued an executive order. Even Shanti gets upset about this. Shanti, please be quiet. He issued an executive order 9066 that, pursuant to which he asserted that he was delegating the authority of the president to the commanding generals in each of the 10 United States military districts to issue military commands that the private citizens in that military district were required, pursuant to Roosevelt's executive order, to abide by. And the commanding general of the first U.S. military district that covers the western half of the states of California, Oregon, and Washington State, issued this order demanding that anybody of Japanese or Oriental ancestry be in their home and be ordered to remain in their home after 7 o'clock at night, this curfew that he imposed. And there was a very famous case, a young third-generation Japanese American by the name of Hirobayashi, that he was out on his lawn up in Seattle, Washington, I believe it was, at a barbecue with his family, and U.S. military forces came swooping in a Jeep and arrested him and brought him and put him in a military stockade and held him there with no right to go in front of a magistrate or anything. The American Civil Liberties Union came to his aid and filed a motion under habeas corpus in the United States District Court up in Washington State, demanding his immediate release, asserting that the President of the United States possessed no such inherent authority to unilaterally issue an executive order like that, and therefore the commanding general of U.S. Military District 1 had no derivative authority to issue such an order, and therefore he couldn't hold the person. Well, the magistrate judge punted on that and turned it over to the federal district court. The federal district court ruled that until such time as he was convicted in some way, that they didn't have jurisdiction to review just his incarceration. And what happened is the plaintiff appealed that to the United States Supreme Court. And the United States Supreme Court sat on that motion all the way up until the middle of 1944, leaving Hirobayashi in the military stockade as a private citizen. And then, as you know, Roosevelt followed up that particular executive order with a later executive order. This was it doesn't probably make any difference to you, but it was executive order I think 9102, which actually authorized the rounding up of Japanese Americans and incarcerating them. And so it wasn't just Hirabayashi that was now incarcerated. It was some, let's see how many. There ended up being some 110,000 Japanese Americans, as you know, that were rounded up pursuant to an executive order by Roosevelt. And again, the United States Supreme Court refused to rule on that all the way until until December of 1944. They left all of those people. Sarah, could I get a glass of water, please? Okay. He left all those Japanese Americans imprisoned, basically in concentration camps until December of 1944. At which point, this is extraordinarily important. The United States Supreme Court, in Ex parte Mitsui Endo, a very well-known constitutional case, ruled that the president had exceeded his authority in doing that, arguing that they didn't have the authority to hold those Japanese Americans in prison any longer than was necessary to sort out those who may have been disloyal from those who were loyal, but that by inference or implication suggests that they had the authority to do it to begin with, but never ruled directly on the question of whether or not the president possessed some sort of inherent authority to be able to do something like that. And the next case that came up was with Truman, President Harry Truman in 1952 during the Korean War. The United Steelworkers went on strike in Pennsylvania against the steel mills, and Truman ordered them back to work pursuant to a unilateral executive order saying that because we were in a state of war or a police action actually with Korea, that he was ordering the United States military to go into the steel mills and take over the operation of the steel mills. A legal cause of action was filed in the federal district court, went to the United States Supreme Court, and the United States Supreme Court ruled that that was unlawful for him to have done that. And there's a very famous concurring opinion, which means that the majority opinion in that case needed to have a concurring opinion that set forth a different rationale for the support of the majority's case. And Justice Robert Jackson wrote this very well-known concurring opinion in which he set forth this set of principles, saying that when in fact the President of the United States undertakes an action pursuant to a specific order of Congress authorizing him to do that, his constitutional power is at its highest amount. If in fact, on the other hand, he acts without any authority of the United States Congress and just undertakes an action unilaterally and doesn't have any specific constitutional authority delegated to him in Article 2 of the Constitution of the United States, and he doesn't have any specific authority from Congress to authorize him to do that, he is at risk in making a move like that. And then he said, in the third instance, if in fact the president undertakes an action which seems to be directly in opposition to what Congress wants to do, either by their implicit actions or by their express actions, they didn't say he's totally without authority to do that. What they said is that his authority would be at its lowest ebb, which implies, again, that the president might conceivably have authority to take certain types of actions, even directly in the face of a congressional ban of him doing that. Now, this, of course, came up in the Iran-Contra case that we happen to have litigated at the Christic Institute, as you may remember, because the Congress of the United States passed the Boland Amendment in March of 1984, explicitly prohibiting the executive branch from granting any aid or military aid or economic aid, either direct or indirect, to the Contras, who were the exiled fascist military commanders of the exiled dictator of Nicaragua, Anastasio Somoza. But it turns out that the Reagan-Bush administration covertly set up a method of indirectly getting weapons to them. We happen to have caught them doing that, the Christic Institute. And we filed a major federal criminal racketeering act complaint against them to get the federal district court in Florida to declare them to be illegal and in violation of the Federal Criminal Racketeering Act. And still, the court in that case did not rule on this. They came up with, manufactured a series of artificial grounds upon which to dismiss the case, basically by rejecting 4 separate sworn depositions that connected the people who were in the enterprise to a particular bombing that you may remember at La Penca, where there was an effort to kill Eden Pastora, the Comandante, one of the Commandantes of the Sandinistas. In any event, this has happened repeatedly, but very importantly, it also happened in the Pentagon Papers case. And you probably remember that I was one of the 5 attorneys for the New York Times in the Pentagon Papers case when the Nixon administration and the John Mitchell Justice Department attempted to secure an injunction to prohibit the New York Times from publishing the content of the 47 volumes of the top secret internal Pentagon study that had been done to try to determine how it is that we managed to, screw up so badly in the Vietnam War. And that the New York Times, we got our hands on this set of documents from Dan Ellsberg through Neil Sheehan, one of the reporters from the New York Times. And I was the one that got called by Jim Goodell, who was chief counsel for the New York Times, to ask if we would represent them and protect them. Because I had done the case that went to the United States Supreme Court that established the right of journalists to protect their confidential news sources. So they had a lot of confidence in my ability to figure out how to make the argument as best we could. And we did, and we prevailed. But in that case, the Nixon administration and the John Mitchell Justice Department was flatly asserting through the United States Attorney for the Southern District of New York that they had the inherent authority to stop the New York Times from publishing any information that they said was classified. And that they had the authority unilaterally to classify information. They had the authority unilaterally to stop anybody from making public any of the information, even if you didn't work for the government, even if you were the New York Times. And we confronted them on that. And I was attempting to get the court to rule on that, to say absolutely not. The executive branch does not have the authority to do this. They've sought this authority from the Congress on a number of occasions to get an American Secrecy Act, like the British have. And the United States Congress has declined to do it. They've refused to do it. Why? When we were in chambers arguing in front of Judge Murray Gerfine, when Whitney North Seymour, United States Attorney for the Southern District of New York, he said, "Your Honor, there is information contained in these papers, if published, would irrevocably damage the national security of the United States." And I said, "Like what?" He said, "I'm sorry, Mr. Sheehan, I can't tell you because you don't have the adequate clearances." And so Judge Gerfine said, "Well, how about me? You can tell me what's in it." And the U.S. Attorney said, "No, you don't have the proper clearances either." And so I turned to Judge Gerfine and said, "Okay, are we done here?" I said, they've obviously got the burden of going forward on this. They won't even tell you what they're talking about. And still, Judge Gerfine would not just simply dismiss their complaint. He said, well, look, show me the papers. Show me what's in the papers and let me try to decide whether or not I think there's something in the papers that would irrevocably damage the national security of the United States. And I said, no way, you know, but, and that's when he entered the injunction. He entered the injunction against the New York Times publishing the papers, a temporary injunction, which he said would last only 3 days, but he wanted the government to give him a copy of the papers so he could look at it, and they said no. So I said, well, good, are we done now? And then he turned and asked Floyd Abrams, our partner at the Cahill firm, and Floyd Abrams gave him a copy of the papers. And so he and his clerks spent 3 days looking through the papers, and untutored by the federal government in any way, they couldn't find anything that they were sure would irrevocably damage the national security of the United States. And so they lifted the temporary restraining order. But that was the first time that there'd ever been a prior restraint ever entered. As a matter of fact, he had asked us if we would voluntarily agree to stop publishing the papers. Well, he had the 3 days to look at them. And I said, no, absolutely not, we won't. And that's why he entered the temporary restraining order. But we went all the way to the United States Supreme Court, and we won the case in 13 straight days, all the way to the United States Supreme Court. They had to go send out special teams to go find Justice Douglas, because this was in the summer. It started on June 13th and went to June 26th. But the justices had already left, and they were all on vacation, so they had to go chasing down Justice Douglas in the state of Washington, climbing up on one of the mountains to get him to come back. And so we did the oral argument, and we won the case. And it's the only case in the entire history of the United States Supreme Court that has 10 written opinions. There were only 9 judges. but every single one of the 9 judges wanted to write his own opinion. And then they had this per curiam opinion. But the per curiam opinion said, we have looked at the content of the documents, and we are unable to determine that anything in the documents, as a matter of fact, would irrevocably damage the national security of the United States. So we don't have to get to the question of whether or not the president had the right to stop the publication, if in fact we were to have discovered something that would have in fact irrevocably damaged the national security of the United States. So you see, this question is a dangerous one. Even as crazy as many people may think Donald Trump is, the fact of the matter is William Barr is not crazy. You know, William Barr knows where the weak spots are in the constitutional system. And he moves right into them, just like David Abington does, just like Dick Cheney does. And so that we who are supportive of democracy and supportive of a constitutional democracy that is not ruled by a king, it has this kind of absolute authority to do whatever he wants under certain circumstances, are pushing to try to get this answer resolved. But the present judicial system is certainly not one that we should go to try to get an answer to it right now, because the United States Supreme Court now has, by 6-3, this heavy majority of right-wing reactionary judges who have been showing all kinds of deference to executive power. And so that this is not a good time to be challenging that. But on the other hand, Donald Trump knows that too. So that what we've been doing is we've been counseling various potential plaintiffs to take great care about not reaching out and requesting the intervention on the part of the federal court system to address some of these constitutional questions right now. And it leads us to the second of the issues that we've been dealing with, and that is this confrontation that's been going on between basically Governor Cuomo of New York and Donald Trump. You know, they have these dueling briefings every morning when President Trump comes on and rambles for like 2 hours complaining about how people are picking on him and not appreciating what great moves he's made to deal with the virus and all that. And on the other hand, then Governor Cuomo from New York comes on and lays out very carefully what's going on with the pandemic, what steps are being taken, what the governors need to do, how they're addressing this. What happened, as you know, is that Donald Trump refused to exercise his authority, even though he kept insisting he had it, to really do anything very effectively about the pandemic. He at first pretended it wasn't true. He characterized it as a hoax, much like he did the entire charges against him in his impeachment. He allowed this pandemic to run wild in the country so that tens of thousands of more people have been killed by this than might have been otherwise. And the bottom line is that the governors, because of that, have stepped forward and have started trying to take care of their own citizens. And they ran into a particular problem. They were trying to purchase personal protective equipment, PPEs, the face masks and gowns, et cetera, that the hospital attendants use, the face masks that the first responders need to use, the ambulance people and the police and others, fire people and all that. And when they tried to buy them in the open market, other states were trying to get them as well. And so that the private companies in the free market system got them into bidding against each other. And so they were actually bidding against each other. And then when the Trump administration was being roundly criticized by everybody for not doing anything to try to supply these masks, the federal government came in and started bidding against the states. And so there were these masks that cost 79 cents a piece to make were being sold by the private companies for up to $6 a piece. And then when the governors did succeed in getting access to some of these masks, the federal government agencies would swoop in and seize them, saying that they had to take them for the federal government to bring them into the federal stockpiles to make a decision as to what states they were going to distribute these to. And what we started to see is that Donald Trump was giving virtually anything they asked for to the red states, the Republican governors in the Republican legislative states, and he was holding back giving the masks and the respirators and other things to the blue states. I mean, it was, well, anybody who knows Donald Trump wasn't that shocked, but anybody who has any kind of constitutional sensitivities whatsoever was stunned at what he was doing. And then Mitch McConnell started whining about, the president giving any relief at all to these blue states, that he ought to be giving it to the red states. It was just like a banana republic, these guys, the way they were acting. And so then you saw Governor Cuomo in one of his morning briefings said, wait a second, what kind of a position is this for McConnell to be taking? Doesn't he understand that we're the United States of America? We're not just blue states and red states. He said that when it comes to them in threatening to stop bailing out the blue states, he said, who's bailing out whom here? He said, it turns out that New York State gives more money into the federal pot every single year than any other state in the country. And they give vastly more money than they ever get back from the federal government. Whereas Kentucky, out of all the 50 states, is the third biggest taker of money, way over and above anything they put into the federal pot. And so who's bailing out whom here? Now, all kinds of people in the progressive community, the people who don't like Mitch McConnell, were cheering for this put down on the part of Governor Cuomo. I was terrified by that. I mean, to hear the states actually getting into this debate about not necessarily supporting a system in which the states give according to their ability and get back according to their need, but were in fact talking about husbanding their own money and providing for their own services and not sharing their money with other states that don't have the same kind of economic engine is frightening to anyone who esteems the United States government constitutional structure. Now, it may well be true that because I've spent my whole life studying and litigating and discussing the Constitution of the United States and the protections that it affords to our citizens, I may be considerably more sensitive to these things than a lot of other people. But that's why you have me on for these type of discussions, to really someone who has a very highly trained set of sensitivities about the constitutional structure that we have, and is completely convinced that the protections that are afforded in our constitutional system were down to the benefit of those of us who are more progressive, because it protects us against the power elite that were represented by Alexander Hamilton and the commercial, the mercantilists that he represented, that did apply their trade pretty effectively in setting up the constitutional structures originally. And they're the ones that don't allow the people to vote directly for the President of the United States, that we only get to vote for the Electoral College. They, at the beginning, didn't allow the citizens to even vote for the members of the United States Senate. They had to be selected by those state legislatures. There's all kinds of ways that the Constitution had elements in it that were really quite conservative and really favored this mercantilist elite in the country. The Jeffersonians and the Madisonians, on the other hand, were putting in the Bill of Rights to protect individuals and to bring to bear the power of the federal government to protect individuals. So this debate that's been going on between the President of the United States and the governors of the states really requires a lot of careful attention right now. And it's the second of the major constitutional issues that I wanted to raise for us. The third one, of course, is this fundamental question about whether the government, the state with a capital S, whether you're talking about the federal government or the state governments, has the right to simply order you to stay in your house, or they're going to send out gendarmes to arrest you if you go out in public without a face mask, or you go out when you're not really going to some place that's necessary, or you go to the beach because you want to go out to the beach. You know, where is that coming from? You know, where does that authority come from? Does it say so in the Constitution? It doesn't say so specifically. So where do they get that kind of power? And, you know, and do the people have a right to go in violation of this, to gather together in large groups, like for example, in the state house of the state of Michigan? And do they have the right to carry military arms with them? You know, M16 rifles around their neck and wearing full body armor, and go into the halls of the legislature, demanding that they override the executive order of the Democratic governor of the state, extending the stay-at-home period. You know, these are profoundly important constitutional questions that are arising. And of course, they're all undergirded by another constitutional question that is going to be confronting us. If, in fact, God forbid, that Donald Trump were to be designated by the Electoral College again to be president again for a second term, even if Vice President Joe Biden wins the popular vote by over 5 million votes. They could still, mathematically, you could figure out with the Electoral College votes that the Electoral College could still, by a tiny margin, designate Trump for a second term. What's going to happen then? You know, if he starts doing this stuff against global climate change, and it continues this disassembling of the entire environmental protection system in our country, you know, are the state governors going to join together in compacts? Are all the blue states going to join together in some sort of, dare I say it, confederation to be able to implement much more aggressive protections for their citizens, undertake much more draconian measures against the corporations that are spewing carbon and other global climate change generating gases into the environment? Are states going to ban the operation of petroleum fueled cars in their state, like California, for example? And what's the federal government going to do then? Are they going to try to send in the National Guard or something to take control of the state? You know, this is an extraordinarily important moment that we're in here. These issues are very much up on the table right now. When you hear these kind of discussions going on, and you have armed people trouncing around in the state capitol buildings, you know, threatening the state legislatures, and a president in place castigating the news media, and declaring them to be the enemy of the people, and threatening their FCC licenses. I mean, this is an extraordinarily important time to take care that all the balances are correct here, and that they stay correct, and that we take care to share the information about our Constitution, and to, very importantly, make clear to the progressives that in these troubled times, we cannot, in fact, cheer over pursuing the short-term benefits that we gain by undermining the authority of the presidency or undermining the authority of the federal government just because we don't agree with the person who happens to be in office. He's in office from a duly elected process that's been established, and it applies to both parties. If we want to change that, we have to consider doing that. But I would warn against moving to start amending the Constitution in this particular moment, because the hardcore right-wing people have the support of a hardcore right-wing set of federal courts right now. And if they made a move to try to implement major constitutional changes, we could be in big trouble, the progressives. And it's my judgment still that the constitutional framework and structure really protects the progressive movement in the country that is attempting to push our whole community and country forward in a progressive direction. Because a lot of people are sort of inherently conservative, and they don't want change. And so therefore, for those of us who are agents of change, we need the protection of the constitutional structures to protect our processes. So I just wanted to get that made clear to all of us. I've highlighted a couple of the major constitutional questions here at the outset. There are others that have to do with, for example, the vaccination program. There's a whole bunch of people arguing that this is some kind of a conspiracy on the part of the wealthy to vaccinate everybody. And do we have a constitutional right not to be vaccinated? If they develop a vaccine for this pandemic, can they mandate that anybody has to be vaccinated in order to leave their house, in order to participate in some public gathering, in order to go to the public schools, to go to a public hospital? You know, these are profoundly important fundamental questions that we need to address. And we've made ourselves available here at the Romero Institute to answer those questions. I'm very grateful for having the opportunity every other Friday to come forward and to talk to our people, to share some of the information about these things. And we can drill down deeper on some of the details, but I don't want to get too far into the weeds. I just want to raise some of these major fundamental questions and assure everybody that it is in our interest to protect the constitutional order of our country. And there are extreme radical elements that will, in fact, assert that there need to be such profound changes in our country that we do not need to abide by the constitutional order, because the constitutional order has been weighted too far in one direction or another from their point of view. This is a compromise that has been struck between the mercantilists on the one hand, the mercantilist elite, aristocratic royalists, represented by Alexander Hamilton, and the individual small town regular people that are represented by James Madison and the natural law, fundamental human rights people. So that this balance has been struck. It's a fair balance at the present time. If we were to go forward and try to amend the existence of the Electoral College, for example, you're striking at the heart of a fundamental compromise that was struck, that we couldn't have even gotten a lot of the smaller states to come in to join the Union if they didn't have that right. They might argue that they have a right to leave if they're not going to be able to have adequate representation in the United States Senate.
So do you have a question you want to address?
I saw one of them here. Tanya asked the question. She said, did Danny actually answer the question about the constitutionality of the government forcing us to stay in our homes or not go out without masks? did I miss it? Or did he just raise the question and then go on to talk about some other constitutional issues? You know, she's right. I raised the question. I can answer the question now, in that whenever a state or federal juridical entity issues an order and it's challenged by the citizens, the court is going to be asking a number of specific questions. There's a specific structure set up. Number one, did the government have a legitimate government purpose that they were authorized to do when they undertook enacting this particular statute or order? Secondly, does it infringe upon any fundamental constitutionally protected right of the citizens? And if it does it do so to the absolute minimal degree to which is necessary to effectuate the legitimate government interest for which the rule has been promulgated? Thirdly, is there any evidence that the motive for the promulgation of the rule had some ulterior motive? Even though they had the colorable authority to do it, and it is infringing to the minimal degree possible, did they have some ulterior motive? Were they trying to limit their exercise of constitutional rights? Were they passing this rule to keep people from demonstrating, for example? Or to keep them from exercising their right of free speech? This is what they call the strict scrutiny test. Now, this right of quarantine has been challenged in the past, and this strict scrutiny test has been applied to it. And the courts have come to the conclusion that so long as the exercise of power is limited and constrained to just meeting the purposes of the statute, the legitimate purposes, then the court will entertain this motion to sustain it or set it aside. In this particular case, you'll see where a lot of these arguments that are floating around would come into play. For example, does the federal government and the state governments, do they have a legitimate government interest in ordering us to stay home in the face of this particular pandemic? Now, you hear all kinds of factual arguments being made all over the place of saying that the fatality rate of this particular virus isn't any worse than the normal flu. That there's been no threat to the major hospitals. Look, there's all kinds of hospitals that aren't overwhelmed at all by this. People can get this disease and not even have any symptoms at all. That there's some sort of major conspiracy going on. That Bill Gates is trying to get everybody vaccinated. Or the big pharma is going to be making millions of dollars on these vaccines. Or there's one world government by Rockefeller that's trying to draw everybody into practicing responding woodenly to these kind of orders from the central states. Under the first question in this strict scrutiny test, all of that evidence can be put in. You can put all of it in and say, look, there's not a legitimate reason for the government to be doing this. And instead of just squealing and hollering at each other about these rights and the terrible federal government that's going to come to get us all, you have a forum in which to do it. You can go in and present all of that evidence to a court and say, look, there's not a legitimate reason for doing this. Instead of just caterwauling, you can go in and do that. You can get standing to do that. The second question is have they done this over broadly? Have they kind of overreacted to this whole thing? Is it possible, for example, is it necessary, for example, to go and arrest a person who's out on the river canoeing all by themselves, away from everybody, not contaminating anybody, not throwing, and they go get arrested, for being out doing stuff that's not necessary? Isn't that a bit of a stretch here? Shouldn't the government be more restricted in the kind of limitations it's trying to place upon us that's commensurate with what the risks really are here? And is there some ulterior motive for them doing this? Is Bill Gates behind this whole thing, or are the Rockefellers behind this whole thing? There are structures that have been set up over the years by intelligent people of good faith, who've set up these protocols and structures pursuant to which really challenging questions can be addressed in times of exigent circumstances. And that's what we really have to do. Now, I say all of that with a caveat that there is a fundamental problem that's been posed right now because of the Trump administration and McConnell having manipulated the political process pursuant to which they kept 140 judges from being appointed during the Obama administration. And they just completely refused to even hold hearings on them, breaching their constitutional responsibility to advise and consent on those appointments. And then when Trump came in, they appointed all Federalist Society people to those 140 positions. And they filled those positions. And then the Republican-dominated Federal Judicial Conference has come together and said, oh, because of the increased population in the country, we have to create 56 new federal judgeships. And all of those were appointed from the Federalist Society, and so there's a total of 236 new federal judges that are all being appointed by the Trump administration. And what they're doing is they're spreading those over the entire federal system in a way that is transparently designed to gain control over each of the federal circuit courts of appeals and over each of the federal district courts en banc. So that they haven't just met any kind of local needs for the judges. They've used this rationale to figure out how to seize control of the entire federal judicial system. And then they populated all of these judicial benches with hardcore right-wing Federalist Society judges, many of whom are just transparently incompetent. Transparently incompetent. They don't even know how.
There is there a lawsuit?
Pardon? No. The problem is that this, unless Congress were to stand up on its hind legs and file a major federal lawsuit against us to try to secure some kind of an injunctive process, but they don't want to do that because they think they're going to be in charge. And so this is what we're seeing is some of the fundamental challenges of an exclusively two-party system. That they're each kind of swapping back and forth in the share of power, and so they don't want to do anything that fundamentally undermines the ability of one or another of the parties to abuse their power. So this is. But in short, what I'm saying is that this whole issue of the quarantine has in fact been looked at in general in the past. There are a couple major, well-known cases that have been decided. Under this, not that anybody's going to look them up or anything, but there's anyway, I can't find it. But there's a big famous case, I think, in 1909, a United States Supreme Court case in which the Supreme Court ruled that so long as the state confines its quarantine to meet the needs of a particular crisis, then they can do this. There's a power that resides here, but that the legislatures have to provide a statute that governs the authority of the executive office to do these things.
Okay.
So
one quick question, Danny, from last time. You mentioned Trump in the face of the 2.2 trillion bailout and the $500 billion going to the large corporation. That he'd done a signing statement saying you can ignore the accountability thing. Whatever happened to that?
The Congress has not done anything about it. The Congress is not, they're the ones that are going to have standing. The reality is that there are a number of different kind of remedies that we depend upon the United States Congress to do in a representative democracy. And if they don't do their job, then we've got to replace them with other people, and that's what we need to really replace a substantial majority of the congressional representatives in both the House and the Senate with people that are much more, not necessarily just much more progressive, but that are much more respectful of the neutral constitutional principles upon which our government has been founded, so that they'll be able to regain the confidence of people across the country, no matter what their particular political ideology is. That's what we need, neutral adjudicators in those positions.
Thank you, Danny.
Danny.
The donors, next Saturday will be at 5 o'clock, and you, if you are a donor, you will hear back.
So happy May Day, everybody.
Happy May
Day.
It's still time to go out and
Workers
dance
of the
around the
world to bring us our food and help us out.
Terrific.